director of the Tashkent International Arbitration Center, or TIAC, and it is my pleasure and delight to moderate today's panel discussion. And the word that I would like to start framing our discussion today is the word optimism. And this word, the word optimism, seems to encapsulate the general or overarching sentiment towards Uzbekistan's economic prospects. But at the same time, as we lawyers say, the devil is always in the details. And today, we're going to take a closer look at the issue of access to justice as one of the most important, or one of the important components of an FDI-friendly regime. We all know that investors need stable and predictable legal environment with efficient local court system and access to alternative dispute resolution mechanisms, including arbitration. And Uzbekistan has been taken, or has indeed taken already, a huge leap to put itself on the global map of international arbitration. It has established in 2018 Tashkent International Arbitration Center, or TIAC as we frequently refer to it. It has adopted the new law, which the international legal community and the UN Commission on the International Trade Law, or UNCITRAL, has recognized as model law compliant, or in other words, as compliant with international best practices. But there's more to the topic of access to justice. We have an outstanding panel today to address these issues from various different perspectives. And let me briefly introduce them to you. We're honored to have with us today Mr. Dilmurod Kasimov, sitting in the center of our panel. Mr. Kasimov currently serves as the Business Ombudsman of Uzbekistan, the position he has held since 2018. In his role, Mr. Kasimov is responsible for protecting the rights and interests of businesses, ensuring a fair and transparent business environment, and promoting private sector development. We're privileged to have Mr. Kasimov's expertise and insights as we discuss the topic of justice for business today. To Mr. Kasimov's right is Mary Ann Birkin, who is an international development lawyer. She's a former partner in 2 international law firms, the former Deputy General Counsel and Secretary to the Board of Directors of the Asian Development Bank, and most recently the General Counsel of the EBRD, based in London. Mary Ann currently advises the government of Uzbekistan on legal reforms relating to the investment climate, and in that capacity she leads the working group for the development of the Tashkent International Commercial Court, a project that she will be talking about during our panel discussion today. We also have today with us Mr. Wim Do on Mr. Kasimov's left. Wim Do is the acting manager for IFC's Creating Markets Advisory Services in the Middle East, Central Asia, Turkey, Afghanistan, and Pakistan. At the World Bank Group, Wim has been supporting governments in over 25 countries with FDI policy, industry-specific investment climate reform, investment promotion programs, as well as private sector development initiatives more broadly. Before joining the World Bank Group, Wim worked as the management consultant at PwC and Ernst & Young, where he advised senior management of multinational corporations in a wide range of industry on location strategy and investment location decisions. To Ms. Birkin's right is Mr. Hansel Pham, who is Office Executive Partner for the Washington, D.C. office of White & Case, where he specializes in international disputes and advisory work. Hansel has particular expertise in international arbitration and litigation between governments and foreign investors, and he has been working on Uzbek foreign investment issues for some 15 years. And last but not least, we are absolutely delighted to have with us Mr. Anton Konov, who is a New York law qualified partner at the global law firm Allen & Overy. Anton leads the firm's CIS practice with primary focus on Uzbekistan. Anton has over 20 years.
673 cases have been initiated actually by the Ombudsman Office, and more than 153 billion soms have been actually recovered but brought back to entrepreneurs. And moreover, the Business Ombudsman Office takes an important role in conducting checks and also the monitoring on the whether the rights of entrepreneurs are protected and provided. And moreover, the subject of entrepreneurship should have the full freedom, and I also would like to take note of that as we speak now about the reforms taking place, the Business Ombudsman Office is strengthening, is monitoring, and moreover conducting it from distance. So we speak about the remote monitoring that have been also initiated. And we speak also about the virtual office, the remote office of Business Ombudsman, that and the entrepreneurs can apply and complain in case their rights are violated. And if entrepreneurs, let's say, apply to any of the public bodies, the function of Business Ombudsman is to monitor whether these complaints have been considered in time, and if it's not done properly or the complaints have not been considered, there are special measures that should be applied in according to the law. And the most important is that, yes, the business ombudsman in such cases can interfere in the monitoring and even to provide their legal kind of advice that the complaint should be reconsidered. So, dear participants of the forum, we all know that a business cannot develop if the conditions are not created. And in our country, the rights of entrepreneurs are fully protected, and all the mechanisms for that have been established. And our distinguished president fully supports entrepreneurs and applies all the measures in order to cope with all the barriers that are in practice. So, and moreover, all the conditions have been created for foreign investors, so that the credibility could be set and the investors could freely put forward their activities in our country. Moreover, we speak about the fair competitorship and the new projects that have been introduced to improve the overall environment, business environment in the country. You know that the kind of basement of the economy is the business, and in case a businessmen are rich, then the country also will be rich. And I'm sure that this forum will help to build a constructive dialogue and will give us very fruitful results. The support of entrepreneurs is the key priority in our country, and I'm sure that this area will help to improve the situation in the country overall. So I wish you good luck. Thank you very much for your attention.
For your very insightful contributions. As I mentioned in my opening remarks, Uzbekistan has been already making significant strides in the field of international arbitration. It has established TIAC, and we have already administered nearly 50 cases, and all of them are international in nature, which means that at least one party is not from Uzbekistan. And under TIAC's operational framework, foreign companies as well as their local counterparts can choose foreign judges, or in strictly legal terminology, arbitrators. Foreign companies and their local counterparts can choose the language of the proceedings. They can choose the law, and it can be English law. In fact, we've administered cases with English law being the governing law of the dispute. We know that yesterday, the president of Uzbekistan, Shavkat Mirziyoyev, has made an important announcement on the establishment of the Tashkent International Commercial Court, or TICC. And we're privileged to have Ms. Marianne Birkin with us, who leads the working group on the establishment of TICC. So, Ms. Birkin, please tell us more. This is indeed a very exciting initiative, and everyone is really keen to learn more about this.
Switches on, yeah, thank you. Thank you very much, Diana, and thank you also to the organizers for inviting me here today. I'm really pleased to be part of this panel session. And I was also equally pleased yesterday to hear the President announce that this year we will implement this proposal to establish an international commercial court in Tashkent. And I must say that TIAC has very much sort of the model. TIAC has done an amazing job in establishing itself as an international arbitration center using best practice. And TICC is trying to do exactly the same. So the court that we are establishing is an international commercial court, which means that it's designated to adjudicate international investment disputes. So the jurisdiction of this court is specifically to deal with any disputes where there's a foreign element, where there's a foreign investor or foreign ownership. International commercial courts are actually quite common these days. It seems to be just the new thing. A lot of countries have established or are in the process of establishing them. There's an international commercial court in Amsterdam, for example, in Paris, in Frankfurt, and in Singapore. And commercial courts are also found in the international financial centers like in Dubai and in Astana. And so the way this court would operate is that it is part of the local court system of Uzbekistan. So it's one of the regional courts of Uzbekistan under the ultimate supervision of the Supreme Court. But it has its own rules and procedures. So it's independent in that regard. We're currently in the process of drafting the law and also drafting the decree will set out the procedures. So this court will have procedures that are not using the current procedures of the Civil Procedure Court, but will have its own that are modeled around best practice. They will a little bit more common law influenced in the way they conduct litigation, which actually has happened in other commercial court, given that most international investment litigation tends to be under sort of common law, whether it's English law or US law. The language spoken in the court will be English. So that will make it easier for international investors to present their cases, so they don't have to translate all their documents in the local language, but they can submit any documents in English, and the language spoken at proceedings will also be in English. Another feature will be that the judges on the roster of this court will be international judges. So they will not be chosen from the local judiciary, but they will be specifically appointed to act as judges in this court. And they will be chosen for their language skills. They have to speak English, but also for their experience and track record in handling international investment cases, dealing with cross-border cases, whether it's investment also or finance. Another feature is that foreign lawyers could plead in this court. So the foreign lawyers could appear in court, can speak in court on behalf of their international clients. But what is very important is that we are proposing that any lawyers, foreign lawyers pleading in the court, will have to be assisted by local registered lawyers. This is a feature in some of the other international commercial courts, and it's actually a good way to get the local legal community and the local lawyers to work directly with the experienced international litigators and sort of learn the trade. So I think what this court is trying to do is really provide a forum for dispute resolution that is instantly trusted and accepted by international investors. Currently, any dispute resolution of international transactions, whether it's investment or finance, tend to be, or the dispute resolution provisions tend to refer to either arbitration, international arbitration, often conducted outside the country, or the courts in the UK, for example, or elsewhere. And so what this is trying to do is bring those cases to this country in the same way as TIAC really was established to help also bring international arbitration cases in this country. The other thing I should also mention that this court would do, it will also hopefully assist TIAC in trying to promote cases to actually, or promote TIAC to be used where the seat of arbitration is Tashkent. Because there is always a concern that international investors has, even when they use an international arbitration center that they would respect, that if the seat of arbitration is here, you may still end up for example, questions on your arbitration clause in the local courts. And in this instance, the TICC would provide the venue for international investors to deal with concerns when it comes to the arbitration agreement. We also think that this court would have a demonstration effect. I think it's important that the reforms that are happening in the justice sector will continue. And this court will hopefully help that. So it will help the local court system, the local judiciary, improve by the standards that it will set. And then finally, I want to say, it really is also a way to develop the legal advocacy in this country. I heard that I think this is the country at the bottom of the list in terms of the number of lawyers per capita. It's not to say, that we need, or actually it is to say that we need more lawyers to practice and help and support businesses in the countries, which includes international investors. And this court will help develop legal advocacy, will help develop the legal profession. I think it's now a lot of law students want to work as prosecutors because that's sort of where traditional path is. But I think it's important for the legal community to be developed, for advocacy to be developed, to also support investors coming in, including to deal with their disputes. So this would be a great opportunity. Thank you.
Thank you very much, Marianne. I, in fact, had some of my colleagues after the announcement yesterday reaching out to me and asking questions like, is TICC gonna replace TIAC? Is TICC gonna complement TIAC? Is TICC gonna support TIAC? So if we just zero in a little bit more on the issue of the support that the TICC would provide to TIAC, are you envisaging at the moment the exclusive jurisdiction, or are you discussing with the working group the issue of the exclusive jurisdiction of TICC over issues related to enforcement of arbitral award, or what would be the mandate? Is it going to be exclusive or not? If you can tell us a little bit more on that, that'll be very helpful for the audience today.
Thank you. I think, well, this proposal is still very much in development, but yes, I think the whole intention is to support TIAC, and together with TIAC, TICC would put Uzbekistan on the map for dispute settlement at international sort of standard, both for disputes in Uzbekistan, but also for the region. So it is the intention to find ways in which we can also help TIAC in dealing with enforcement of its judgment. So if this court could also support the enforcement of international arbitral awards, including through TIAC, I think that also would be another tool to help investors not only speed up the process for enforcement of their awards, but have a forum that they are trusting. In the end, using the judiciary is very much to do with trust and predictability, and I mentioned at the outset. And this is a concern right now, in that if you use the local court system, it is for investors cumbersome. There's a lot of bureaucracy. There's the need for translations. There are processes that I think work. There's no reason to believe that they will not be working, but they're not easy to understand or for easy to implement for foreign investors. So we're helping specifically them to use dispute settlement in this country in a way that they are trusting and that is supporting this to be done in a speedy way. So yes, it's very much supporting TIAC. I think we're working very closely, Diana's in our working group, to make sure that the two are working together and that we enhance really the international dispute settlement in this country, and perhaps even include mediation there as well. I think we heard from the Ombudsman the need to try and settle disputes before they even go to court, whether it's through the Ombudsman, whether it's through mediation, arbitration, or ultimately a court. So we're trying to really bring all these things together. And I think we've seen great leadership, starting with TIAC, with the Ombudsman. So TICC is a complement there, and I'm really pleased, with the progress we're making.
Thank you very much, Marianne, for your insightful comments. And if we take a step back, and Mr. Doe, I know that you are the representative of an international financial institution. Why do you think FDI is important to Uzbekistan? What is the role of investment law in promoting new investment in Uzbekistan? What's your take on that?
Thank you, Diana, for the earlier introduction, and thank you also to the organizers for the invitation. And before I respond to the question, I have to say this is the first time I'm back in Tashkent in 5 years' time. And it's very exciting to see the amount of progress that has been made in various areas, whether it's on the legal framework, the institutional frameworks, the business community. So much has happened in these last 5 years. And I have to say, as IFC, we are very proud to to partner both with the business community and with the government on this very exciting journey of transitioning towards a fully market-based economy. So very excited to be back. And as the only, economist on the panel, I felt like I would love to speak a little bit to the strategic context around which we discuss issues of investment law, issues of international arbitration, and so on. And that's the whole issue of investment, especially also foreign investment, and the importance for the transition process. As we have seen from the earlier transition economies in Central and Eastern Europe, FDI actually plays a crucial role in the transition process, not just because it's going to bring capital investments and potentially employment to the country, but especially also because of what we call the indirect benefits of foreign investment, which has really much to do with bringing new technologies, new know-how, integration into regional and global value chains, increased productivity of operations, all these things that are really important in order to make a successful transition. Having said so, FDI is never automatic. FDI needs to be managed through the right policies and through the right legal frameworks. And we'll get to investor protections and guarantees and all these important things in a few minutes. I was actually very pleased yesterday to also see the Minister of Economic Development from Hungary sitting in the plenary session. I think there's a lot that can be learned from the Central Eastern European experience when it comes to economic transition, and especially also when it comes to the role of FDI therein. I think what we have seen in Central and Eastern Europe, all the countries have been highly successful in attracting FDI, but they all went also through a cycle. And initially the cycle consisted primarily of privatization-related FDI. And then in parallel, so-called greenfield FDI started to pick up, sort of companies coming and setting up factories. And the reason I'm mentioning that this is so important is that initially kind of the privatization investments may have certain social outcomes. And what we have learned from the Central European experience is that the parallel development of greenfield FDI is incredibly important to absorb some of the labor that may come out of the privatization process. And again, the reason we're sitting here to discuss justice for business and the importance of kind of legal frameworks and legal protections for investors are all very important in order to make sure that we manage to attract investments on both fronts and in parallel right from the start. My final comment would be on the vision and the strategy that the government has laid out. It's a very ambitious vision. My understanding is that the estimates are that Uzbekistan needs 120 billion in private investment over the next 5 years or so, of which maybe 70 billion is expected to come from foreign investors. So to put things in perspective, that's kind of roughly 14 billion per year. And if you look at kind of the FDI levels that Uzbekistan has been attracting till date, you're talking basically a 7-fold increase from pre-COVID FDI levels. So this is no small challenge. And again, that kind of just to underline the importance of getting the legal frameworks right, getting the investor protections right, and the investor guarantees laid out and clarified as much as we can, especially looking kind of at these legal instruments and the institutions, whether it's the International Commercial Court, which is a very important initiative, through the eyes of international investors and what they need in order to feel confident in Uzbekistan as indeed the kind of the destination to invest when looking at Central Asia in general. So let me maybe stop here. Just a little bit of context to underline this is a really important topic.
That was very helpful.
And getting the legal frameworks
Thank
right
you.
is going to be very important for the transition process.
Correct. Thank you very much, Mr. Doe. And I know that IFC has been doing some work on the new FDI law, which was very recently adopted, relatively recently. What do you think? Does it provide sufficient protection, or we always say that there's always room for improvement? So what's your view on that, on the new law, FDI law that Uzbekistan has passed in 2019?
So the IFC has been working very closely with the government on doing a review of the investment law. I think generally the 2019 law was a big step forward in terms of investor guarantees and protections, but there's always room for improvement. Generally, I think it covers all the main investor protections that investors would be looking for. It's there in the law. Upon review, we felt that there's probably where gains can be made is in clarifying some of the language, the way things are written, to just take out any ambiguity. And one of the areas is especially also around investor-state dispute resolution, the exact process through which it happens, the conditions for moving to the next phase, and making sure that all of the international investors will have access to international arbitration. That's a very important consideration for most investors. Yeah, so that's kind of one thing I think that also fits with the general narrative of the forum I would like to highlight here.
Absolutely. Thank you very much, Mr. Doe, for your comments and feedback. We very much appreciate that. Mr. Pham, I know that you are a partner in global, or in one of the leading global international law firms, White & Case. What is your perspective as a partner of the leading global full-service law firms on investment protection in Uzbekistan?
Thank you, Diana. I'm so pleased to be here at the Tashkent International Investment Forum. I've had the pleasure of working with Uzbekistan for the past 15 years, working closely with the Ministry of Justice in particular. And I really share the optimism that you spoke about in your opening remarks. I feel like every year the future looks brighter and brighter for Uzbekistan, and no more clear than at this forum when you had such enthusiasm for a very outstanding plenary with the President and a number of other distinguished panelists. A lot of this has to do with attracting investment, and so much of that is based on having the proper legal framework and the protections in place. And so when investors think about investing in Uzbekistan or any market, there's a number of considerations that will go through the minds of these investors and their legal counsel. First is looking at the laws relating to foreign investment. We've spoken a little bit about that, the recent law on foreign investment that was enacted in 2019. And there's a number of other Uzbek laws that relate to foreign investment. In fact, if you look at this very handy guide on investment in Uzbekistan on page 46, there's a number of descriptions of these laws. And I can speak about them more. But it's not just what law is written, but how is it enforced and implemented. And in that respect, you of course have the Uzbek courts, which have been continuing to improve. You have this very exciting initiative that Ms. Birkin spoke about with the Tashkent International Commercial Court and the Business Ombudsman that Mr. Kasimov spoke about. So all ways in which you can rely upon the Uzbek laws for foreign investments. Aside from Uzbek laws, there's also potentially international law protections. If there is a treaty in place between Uzbekistan and the home country for an investor. I can say more about that, but there's a number of very important protections, and this is something that the foreign investors do care a lot about, as Mr. Doe mentioned, having access to those investor-state arbitration mechanisms for dispute settlement. You may also have the ability to obtain investment protections through a separate investment agreement, something that is signed specific for an agreement for an investment between the foreign investor and the state, making certain commitments in return for certain obligations from both parties. That is a very important way to make sure that whatever concerns you have that may be specific to your investment are covered and are being appreciated and respected. A fourth and final way to protect investments is through political risk insurance. And this is the ability to obtain insurance to cover political losses or losses due to political decisions or activities and measures. This political risk insurance can come from a state-sponsored institution. There is the Uzbek Invest International Investment Company, which provides political risk insurance for a number of different political actions relating to expropriation or the inability to move currency and transfer currency. There may be multilateral agencies that provide this political risk insurance, such as MIGA, the Multilateral Investment Guarantee Agency, part of the World Bank, which Uzbekistan is part of. And then finally, you may get political risk insurance from a private source. And I know that, I think I recall that Uzbekistan requires that insurers private insurers provide such political risk insurance. Those are the general types, and I'm happy to speak more about any one of those.
Absolutely. So what types of legal protections do foreign investors have in doing business in Uzbekistan? A more specific question.
Sure. I think we really do want to focus on the foreign investment law. And the foreign investment law from 2019, it really consolidates what had been a number of different foreign investment laws. It consolidates it, it makes it very comprehensive, and it is a very big step forward, as Mr. Doe mentioned. There are very comprehensive protections for investors about fair and equitable treatment, protections against expropriation, protections against, again, restrictions on currency exchange and the repatriation of dividends. there is a very, I'd say, broad and liberal clause which protects investors if there is a subsequent change in legislation that is less favorable than prior legislation. The investor will be able to rely on the prior legislation that was more favorable. Really quite a broad array of protections. In addition, the foreign investment law sets out some very helpful avenues for foreign investors. It's, you know, the Ministry of Investments and Foreign Trade becomes a one-stop shop for foreign investors, both in terms of counseling, getting information and assistance. You heard about the Ombudsman's office to assist with dispute resolution. The law on foreign investment also provides a cascading series of dispute settlement options. I think this is what Mr. Doe was talking about in terms of the need for clarity. It starts with the ability of foreign investors to negotiate their problems and try to seek a resolution through negotiation. There's an option for mediation. It then can go to Uzbek courts and hopefully will include the Tashkent International Commercial Court. And then finally, there is the option for international arbitration if there is a consent already provided either in an investment agreement that I talked about or one of those international treaties. So a very strong investment law goes very far.
But what about the international law protections? So we've touched upon the local Uzbek law on FDI. What about the international law protections that the foreign investors should think about when investing in Uzbekistan?
I think some of the international law protections are among the most important. We see that in advising foreign investors in Uzbekistan and elsewhere, that they care a lot about the types of obligations and protections that are contained in treaties. So this may be in what's called a bilateral investment treaty, a treaty between two states, Uzbekistan and the home country, or maybe a multilateral treaty where there's more than two states involved. If you take these bilateral investment treaties or BITs, these are a very important source of protections for foreign investors. I understand that there's over 50 of these BITs that have been signed by Uzbekistan, some 45 are in force, and this is a very active source of a very active way for foreign investors to assert their rights. What these treaties provide is that if you are an eligible foreign investor making an eligible investment in Uzbekistan, there's going to be a number of protections. And the Uzbek BITs tend to have very comprehensive protections about having to provide fair and equitable treatment, protections against expropriation, getting full protection and security, having to comply with obligations made by the state with respect to investments. And very critically, very often, most of the time, these protections are backed up by recourse to international arbitration. These international arbitration can be in front of ICSID, that is the International Center for Settlement and Investment Disputes of the World Bank, a very established arbitral institution, or they can be under the UNCITRAL model rules, which is also a very well-known set of rules. While we're speaking about arbitral institutions, I do want to make another shout out to TIAC because it is really becoming quite a player. Just from its few years, we already see it being very popular, of course, in Uzbekistan and the CIS region, but with so much potential to be a broader player in the larger market. And it's not only because it has some of those best practices that Diana talked about in terms of allowing foreign laws and foreign arbitrators. There's some really special and unique aspects of TIAC. One is that there's no administrative fee, and that can be something pretty significant for our investors and clients, and even the governments, bringing arbitrations there. It's just a fee that is usually paid to the arbitral institutions, which can become significant over time. I think TIAC also has best-in-class provisions and restrictions on conflicts of interest, such that the TIAC staff, the Court of Arbitration, the Diana herself, cannot serve as an arbitrator under the TIAC rules, making sure that there is real neutrality and independence. So those are very strong attributes which are tough to find elsewhere. But there are so many of these international protections really coming into play with the treaties, and again, that's something that we have dealt with quite a lot.
Thank you very much. And probably the last question would be, how should investors maximize their legal protections for their investments in Uzbekistan? What is it that they need to do to maximize those protections that are available under local law as well as international law?
Well, sure. Certainly, as a lawyer, this first part will be a little bit self-serving because I think it's going to be very important to make sure that you're speaking with legal counsel, doing due diligence to understand what legal protections are in place, what can be obtained through intelligent structuring and negotiation of investment agreements. Once you know what obligations are there, how do you make sure that you are able to access them? And a lot of that is just behaving in the way that a good and conscientious investor would, things that are very natural. Of course, you'll need to have compliance with Uzbek law. This is a very important requirement, not only in the Uzbek foreign investment law, it is a requirement in many of their treaties. Similarly, if there is an investment agreement or if there's some obligations that come from obtaining a concession, the investor needs to make sure that it's complying with those obligations so that it is earning the benefit of the counter and reciprocal obligations from the government. Pretty standard, I would think, but those are important things to consider if you want to rely on the many investment protections that Uzbekistan provides.
Thank you very much. Thank you, Mr. Pham. And Mr. Konov, I know we have another prominent representative of the international or global legal community with us today. I'd like to ask you the question around the preference or why the national courts are usually the least preferable forum for the resolution of the in investment disputes, so to say. And we're talking about general framework. We're not referencing Uzbek courts in particular. But why do you think this is the case? And given that we have TICC's establishment on its way, so what is it that we need to take into account when developing the framework for TICC?
Yeah, thank you, Diana. And it's a great pleasure and honor to be here. Thank you very much. I think to address your question, maybe I should make one step back and just to say, so when a dispute would typically arise, and I think many lawyers will tell you that actually a dispute will arise at the time when you start negotiating and drafting a contract. It is at that point of time where you or your lawyers need to start thinking about what is going to happen if a dispute arises and where we're going to go. Now, I'm saying they should. In reality, often they don't. And I can even say there is such a legal, in English jargon, which is called boilerplate clause, which is basically a standard clause of an agreement, which is generally not supposed to be negotiated. So what, as consultants, as advisors, what we see in practice is that we have a 200-page agreement, which parties negotiate for months and months and months, and they're very much focusing on commercial matters, rightly so. And then 20 minutes before they sign, then, and I'm sure Hansel will confirm this, they run to our litigators and say, well, look, we now need to agree dispute resolution clause in our complicated agreement. Can you please give us a sign-off? And that's the best case scenario. The usual, often scenario is that where people don't even think about what they put in, and there is just some standard clause which slips in. And of course, that's not the right approach, because typically what you put in the agreement in terms of your dispute, and equally this often applies to governing law as well, it determines how the dispute will be resolved, how efficient it will be resolved, and frankly, what leverage and negotiating power each party will have. Because if one party didn't think about the dispute resolution mechanism they've agreed, you know, they may lose a lot of leverage in resolving the dispute. Now, you know, talking about getting to your question about the courts, I think, again, to remind ourselves, there are several, first of all, options how we can resolve disputes. So the first one is indeed national courts, yeah. And as you rightly say, the fact is that, you know, this is perceived to be the least preferred option, at least from the foreign investors' perspective. Then we go on to other judicial options, and indeed many jurisdictions will have specialized courts. In some cases, this would be some institute similar to the TICC that we've just discussed, and indeed many jurisdictions, but not all, have these court systems, which are specialized, which are often distinct to the general judicial system, the general court system, and have many advantages. The third option would be foreign courts. Often you see foreign investors insisting either on their home country court system or just general neutral state court system. And last but not least, arbitration, of course. Yeah. Now, you know, we also talked, of course, about mediation and other alternative method of resolution. We also need to remember about those. They also need to be thought through, and in some cases they are strongly advisable, in particular where we talk about specific disputes such as construction and the like, where methods like expert determination or mediation or other alternative methods, you know, would be most appropriate. Now, getting to national courts, well, that's an interesting topic. And when someone says, well, look, you know, we don't prefer, you know, your local courts, that's often not perceived very well. And I think from the lawyer's perspective, national courts, they, on the face of it, they do have a number of advantages. I mean, we shouldn't forget about those. So, first of all, it is objectively the cheapest and in most cases quickest process because their fees, they are very much regulated. The stamp duty is often rather minimal. You know, yes, you do need to spend money on lawyers, unfortunately, but you would probably be spending on them less than in other methods of dispute resolution, at least in arbitration. And they are relatively quick. Most of the court systems, case in the first instance will take, in most of the jurisdictions, between 2 or 3 months, maybe to a year. Whereas if we talk about a complex arbitration, typically we'll be talking year plus, 2 years, 3 years in some cases, so it's a lengthy process. There is another advantage of state courts, is that typically states cannot claim sovereign immunity in their local courts, and as you know, in many countries there is a respect for sovereign immunity, so absent a specific waiver of sovereign immunity, it is impossible to sue the state outside the state, if we talk about the state. And lastly, enforceability, though this is more complex than it sounds, but if we talk about enforcing a judgment in the local jurisdictions, if you, as a foreign investor, manage to obtain the local court judgment, and if it is in your favor, then there are good chances that you can enforce it locally. So these are the advantages, and for a number of the disputes, the national courts would be appropriate mechanism, so I'm not saying it is not. But there are two main, I think, issues that typically concern investors. And when I'm now saying investors, I primarily talk about foreign investors investing into the country, though frankly it does apply to an extent to local companies as well. One is objective and the other one is subjective. Objective is the lack of experience and expertise. It is just the fact that, you know, judges in the state courts. They simply cannot have that level of specialized expertise in a particular dispute. They're also under enormous pressure from the procedure which they need to follow to resolve disputes quickly, and they just objectively cannot pay that much attention and apply the same level of expertise that you would be able to achieve in arbitration. It's just an objective fact, even in specialized courts. The other one is more subjective, but it still exists, and this is the issue of a perceived lack of impartiality. Most of the foreign investors will be concerned about that, and in particular, if they're to deal with the counterparty, which is a state or a state-controlled company or an influential local player, there will be concern about the impartiality of the court. Now, whether this is true or not, that's a separate question. The important point is that there is a perception that you need to address. Now, to your question about how we can address it, I think you need to address 2 points. You need to address lack of expertise by, of course, introducing this experience and expertise in local courts, including through, in some cases, creation of such institutes as TICC, for example, where it is easier to introduce judges with specialized expertise. And also it is important to maintain impartiality. Now, that requires time. I think it requires a pattern of a behavior of a court which is proved to be impartial and independent. So I think these are the 2 factors that I think is important. Now, I probably would just say a couple of words about arbitration if we still have.
But since you've mentioned about the approach or that perceived lack of independence of national courts, and again, we're not discussing here Uzbek courts as such. I know that Mr. Konov has explained about the general perception, but I think 2 points that I personally really like to mention in conferences and forums like this one is the fact that there are already certain cases which were considered by Uzbek local courts, and in those cases we've seen judgments which recognized foreign arbitral awards that were issued against state-owned enterprises of Uzbekistan. I think this is really the testament to that approach, to that independent approach of the local courts. And another important point that I would also like to emphasize on. In the history of Uzbekistan, there hasn't been a single court case in which a foreign arbitral award has been refused recognition on public policy grounds. I think this is very, very important for the investment community, and I just thought that I will just chime in and make that comment. But probably another question that, since you've mentioned about the foreign courts and English courts in particular, what would drive the choice of a foreign investor, and why would they prefer foreign courts like English courts, for example? Yeah. Mr. Konov, the question is addressed to you. Yeah.
So I just wanted also to pick up on your comment about the practice of courts. I think actually your latter example is more important than the former, in a sense that I think it's important that local courts has not refused recognition of enforcement.
Indeed, it is very important.
Because we know many countries, or some countries, who are not quite notable for refusing to recognize arbitral awards. And I'm not saying that there are grounds for doing that often, and it's not illegitimate to do so. But, once you have a pattern where a state continuously refuses to recognize foreign arbitral awards, this is a sign. And it's, you like it or not, but it's typically not a good sign. So I think the fact that here there have been no cases of refusal, I think it's a good sign.
And there have been attempts, multiple attempts, to set aside an arbitral award on public policy grounds, and all of them failed.
Yeah, to your question on the kind of foreign courts versus national courts arbitration, well, there are several reasons why foreign investors would want to opt for foreign courts. Because, well, first of all, they would view them more impartial in comparison to local courts. For example, if we talk about an investor coming from Europe to Uzbekistan, so if they have a choice between an Uzbek court and an English court, for example, which is a very popular, of course, choice, they would view English court as impartial. They would view, and that's true, that still English courts would often be quicker. They will have a regulated procedure. In many of those courts, again, English is an example, there will be availability of experienced judges. Again, maybe not to the level of the same expertise as you might get in arbitration. You have an effective appeal system. You arguably have lower cost and better speed. So there could be situations where a foreign investor would say, well, look, I really think that arbitration is a little bit far too complicated. It is not really right for that level of relationships we have because they are maybe not too complex. The important determinative factor is also enforcement, because the beauty, of course, as we all know, of arbitration is the pretty much global universal enforcement of arbitral awards, because most of the countries, they are parties to New York Convention, and at least theoretically and typically in practice, you can enforce any arbitral award pretty much throughout the whole of the world. Now, in courts, it's not the case. It's often a matter of either reciprocity or presence of a treaty. So it really depends on what the dispute is about, where your assets are. For example, if your assets are in UK or in EU, then English courts could be appropriate. If not, then they may not. One thing I should perhaps also mention that there is a perception that when we talk about arbitration of foreign courts, that's always in favor of foreign investor. And I think that's not quite right, because this, I think, perception is based on the assumption that the local partner, the local company or state-controlled company, there will be defendants. And if they're defendants, it's better to defend yourself in a local court. Now, the truth is that it's not the case at all. Often you do have, as a local partner, a lot of claims, indeed, against your foreign counterparty, supplier or constructor. It's not completely uncommon. In fact, it's very common. And if you think about it, if you subject your case to like a local court and need to enforce it in some jurisdictions which doesn't recognize Uzbek court judgments, I think you will be thinking twice whether that's the right choice or not. So the other point to make is that I don't think there is, we were just talking about all that just purely from a perspective of foreign investors. We often talk about it from perspective of both sides. And the choice really needs to be done on an ad hoc basis, specific to a particular contract or dispute, and so on and so forth.
Thank you. And what about the law? We've heard about the popularity of English law, say, for to govern certain contractual relationships. But what do you think what law the investors and local companies should choose to govern their contracts?
It's a very good question. I've been practicing for a long time in Russia, of course, and English law was extremely popular. And, I've heard so many times, why do we need to use English law? Like, why? Why can't we use Russian law? Why it should be English law? So it's a very popular question. Now, I think there are several points here. The first one is that in most of the developing countries, or the countries with the fast-growing economies, actually, the legal system and judicial system is behind the development. It's just a fact. I mean, lawyers are very slow and legislators are even slower. So they're always like several years behind. And for judicial system, it's even longer because you need to test it, it needs to be consistent, and so on and so forth. So the reason why foreign investors and frankly local companies, I can tell you that, again, in Russia as an example, we had many purely local, frankly, contracts which would be governed by English or New York law. So the reason why they're using this foreign law is quite pragmatic. If you have a complicated, complex arrangement, you would like to have a predictable, enforceable result. So the beauty of English law, whether we like it or not, is that this is a very flexible judicial system, and it is very predictable. And that's what most investors or commercial parties know. I mean, the same, frankly, applies to a number of other laws like New York law. But again, in that part of the world, I would say arguably English law is probably slightly more popular than New York law. And, you know, people are using this, you know, for quite pragmatic reasons. And there is no particular attachment to, with all due respect, to Britain or US. So there shouldn't be no nexus to US or to Britain to use English law. And I think we will see this trend evolving here as well. I expect that there are more investments we will see in Uzbekistan coming in, and the more we will see English law coming here. I don't think people should be concerned about or afraid because no one cancels local law. Local law will continue to play an important role in many spheres. Actually, majority of the contracts will still be under local law. We're only talking about a relatively small fraction of investment time contracts which might be under English law. And eventually, once local law will develop and the judicial system will prove to be impartial and expertise-based, I think we will see the same actually without the pattern that we started to see in Russia in the past 5 years, where more investment type contracts started to become locally law governed.
Thank you very much. Any of the speakers have any further comments or contributions? Yes, please, Maria.
I just wanted to say that the TICC is the answer to all the issues just raised, because it will be experienced, incapable international judges who are impartial. The TICC will have a court of appeal as well. So it really would enhance enforceability in the country. So I think it's one way to support cases that are currently going outside the country. And I actually mentioned this in the discussions with stakeholders here, including the Supreme Court, is how many extra cases, are we dealing with cases that are currently going somewhere else in the local court system? Are we taking them away from the existing commercial courts? And my point has been, no, these cases would not have come here. They would have gone to London, to Singapore, to some
Netherlands,
no. And now they are coming. We're trying to bring those cases here. So that is what this is trying to do. So thanks for
that. Is absolutely
I absolutely agree, and that's why I wanted to shortcut this much lengthier process of the national courts. And as you mentioned, I think we have a very good example. Well, first of all, there's an example of that in Astana, but also there's, of course, a very successful example in Dubai, which is quite impressive.
Absolutely, and definitely in terms of the caseload, we all know that our judges are overloaded with cases, and when we talk to them, there's always that discussion that we help you, we as arbitration services providers, we help you, we relieve some of the caseload from your shoulders. So definitely there's that complementary function of TICC as well as TAC to the local court system. Any further comments or remarks? Please, Hansel. Yeah.
I also really want to agree with what Anton said about governing law. So much of when I am actually approached by my corporate colleagues about a dispute resolution clause, not all the time, and always late. there is a preference for New York or English law, sometimes just because of that predictability that Anton was speaking about. And it's not because the law is better, it's just that we have many, many decades of cases that we can draw upon. We can see the trends. We know that this is likely to go a certain way, so we can plan. And that is so important to foreign investors, just having that legal stability. So when you have a country like Uzbekistan that is really coming into its own, but doesn't have that long history, that's really where some increased transparency will assist. And we see that there are transparency requirements in the foreign investment law and separate laws on transparency, but just showing the world, showing foreign investors how courts react can, over time, provide some of that predictability that makes other governing laws so attractive right now.
Yes, please.
Yes, so listening to this very interesting kind of conversation around courts and disputes, and like you mentioned, some of the courts kind of and the judges being overloaded with cases, it just struck me that there's also something like prevention is better than cure. And many of the countries where we work, and I know here in Uzbekistan also, you have a national agency for investment promotion, and as part of the mandate of these agencies, they have a so-called investor aftercare mandate. So it's not just about bringing investors to your country, but actually once they're there, staying in touch and making sure you understand what their problems and the issues are. Many countries set up so-called investor grievance mechanisms. It's like one step before dispute. Investors have a grievance, and then through these kind of independent grievance mechanisms, see how you can resolve some of these cases very, very early on, before they become a dispute and before they become a very expensive international arbitration recourse. And I know, for example, in the case of Georgia, they have organized the grievance mechanism through the National Ombudsman, very effective system, and there may be other opportunities kind of how to organize it. But yeah, prevention is better than cure.
Absolutely, I fully agree, and I think there was a discussion about establishment of some form of dispute prevention or dispute avoidance committee. So this discussion has indeed taken place already in Uzbekistan. But on the transparency point, I fully also agree with Hansel, and I think another point to note on the local court system, a lot of court judgments are in public domain, such as, for example, those that I have mentioned, which were issued against state-owned enterprises of Uzbekistan, and all of this is in public domain. We at TIAC have been proactively asking the parties to our dispute to provide consent to the publication of our arbitral awards in redacted forms, which means that users and future parties would be able to get access to judgments or arbitral awards in redacted forms and see the quality of the decision making. So I fully agree that transparency is very important, and we do take steps to ensure that. Any further comments? Please, yes.
Да, рұқсат берсеңіз, я на узбекском.
Yes, if you allow, I will speak in Uzbek. Yes, of course, international courts are developing now, and this is very important. It's a very important mechanism, important system. And as you also just mentioned, our president is building a lot of organizations that actually regulate ensures this pre-trial dispute resolutions, such as ombudsman or some committees. And so our distinguished president has launched judicial reform. You know that about appeal also mechanism. And so it's a big focus for our reforms. And I think that, yes, when an investor comes to Uzbekistan, he has the right to go to any court. We have always supported this free choice. But in terms of local suits, I should say that they are developing as well. So Thank you very much. Mr. Kasimov.
I think we're almost reaching the end of the session. I would like to thank our panelists today for this very interesting and engaging discussion, and I hope that the audience today has also benefited from the discussion today. And if you have any questions, you can approach us individually after the session. Thank you very much.
Thank you, Diana.
Thank you. That was very nice.
Stand up.
Ah, oui, c'était ça.